Here with reaction to this, and also big news from the Second Circuit Court today. We have the President Trump's counsel, Jay Sekulow, also the Chief Counsel, American Center for Law and Justice. Sir, your reaction to this and on the court ruling?
Well, I think, look, they're now talking about a second whistleblower, and my statement on that is, so what? We've already released a transcript. So is it really relevant what some other person who may or may not have heard the conversation thought about it? The transcript has been released. It is out there in the public. So, again, you know what? They couldn't get Russia. They couldn't get obstruction. Then it was quid pro quo with Ukraine. Then there was a transcript that showed no quid pro quo. Then it was a cover-up, except there was no cover-up because the transcript was released. Then it was the whistleblower, and what did the whistleblower do? The whistleblower said, well, no firsthand knowledge for most of it, and then didn't bother to tell the inspector general that the individual was in conversations with Adam Schiff because, of course, Adam Schiff said none of us had any conversations with the whistleblower, which ended up, of course, not being true. So now do we have a second whistleblower. Again, the transcript out, it speaks for itself. It is not an impeachable offense, period. Now, number two, U.S. Court of Appeals for the Second Circuit today recognize, I like reading the exact words of the order. The case is Donald J. Trump, plaintiff appellant, versus Cyrus Vance, who's the district attorney for the county of New York. We filed a motion seeking an order temporarily staying the enforcement of a subpoena that was given to the president's accountants. What do they want? Tax returns. What do they want in California? Tax returns. What did the court in California say? No tax returns. That's not part of the qualifications for office. The House of Representatives basically extending their investigation through a local DA. The words of the subpoena, verbatim, the words of the House subpoenas. Verbatim. Then what happens? We go to the Second Circuit Court of Appeals and they issue this order. It is hereby ordered that a temporary administrative stay is granted pending expedited review by a panel of the court. A scheduling order will issue in the ordinary course. The court also said because of the unique issues raised by this appeal, those unique issues, Sean, is really at the heart of it is the Constitution of the United States. And whether I'm wearing my hat as the president's lawyer or as chief counsel of the American Center for Law and Justice, you have to protect the Constitution. That doesn't just protect a president, that protects all of us.
Hey, Jay, it's a post-constitutional America. The great one, Mark Levin, said it. I mean, they want to stack the courts. They want to get rid of the Electoral College. And for 3 years, no evidence of anything, and same liars, same conspiracy theorists, just the same thing that we've had for 3 years,
I'll
just
tell you
a
what
different
it
country.
is. You know, Sean, what they've done is they've tried to weaponize the execution of the Constitution. The president's exercising his authority under Article 2. They're trying to make that some kind of inappropriate act. They're weaponizing the Constitution. But here's the good news. We're winning in court. We won in California last week. We got the stay today. I'm confident we win in the end. I think this impeachment inquiry, whatever they want to call it, goes nowhere.
Call the vote. Call the roll. I want them all to vote.
They're not doing it now. They're not doing it this week or next. I don't believe it. I don't think they're going to do it.
I hope they do. Do it. I dare them. Do it. American people are fed up with what they've done to this country. Nothing. They're sick of it. They see this for what it is. All right, Jay Sekulow, thank you.